Hello, everyone, and welcome to Crime in Court. This is the Canton cover up series, Commonwealth versus Karen Reed, and this is episode 104, No Justice the SJC Doesn't Care About Double Jeopardy. And I have titled it that because we recently just got the SJC response. They denied Karen Reed the opportunity to call back the jurors or to make Bev call back the jurors. They denied her the opportunity to do anything about the fact that she may have actually been acquitted on charges 1 and 3. So we know it's denied, but we're still going to read through it anyways and see kind of what they say. So we're going to read through this. Um, Response from the SJC. We're going to kind of skip, though. We're going to skip through some of the background because we know all the background already. We'll just get through the discussion. So please hit that like button and let's begin. All right, so number one, propriety of declaring a mistrial. The double jeopardy clause of the Fifth Amendment to the United States Constitution generally precludes the Commonwealth from trying a defendant more than once for the same offense. Obviously, we know that's what that means. You're not supposed to, once you're acquitted or found guilty, you can't be charged again on the same crimes, the same charges. Excuse me. I'm still recovering from the flu, so pardon me as we get through this. Federal double jeopardy clause applicable to states by the 14th Amendment. So just a reminder, the SJC is still Massachusetts. So we're still in the state level of appeal. So we do know that after this was denied, they have since appealed federally. It's not even an appeal, it is a brand new petition basically stating some of the same things. We will actually get to that. It's a 700-page brief that was filed in federal court for Karen Reed as they're trying to get um, her cleared of charges 1 and 3 because she was acquitted. So that is what's happening. Like I said, it's 700 pages, but the brief itself is only 35, and then the rest is like attachments. So we will at some point read through that brief, just so you're aware, for the federal courts. However, an exception to this general rule applies when a mistrial is declared due to manifest necessity. In such instances, the double jeopardy clause does not bar the state from retrying the defendant. To determine whether the declaration of a mistrial is manifestly necessary, a trial judge balances the defendant's valued right to have his or her trial completed by a particular tribunal against the interest of the public in fair trials designed to end in just judgments. A hung jury has long been recognized as a traditional example of manifest necessity, allowing retrial without offending the defendant's double jeopardy rights, which I think shouldn't be the way. If you fail, I mean, the state failed. If you get a mistrial the first time around, the state fails. So you shouldn't have a second time, but that's my opinion. I don't know why. Sometimes they can just keep coming at you. There was a gentleman by the name of Curtis Flowers. Can't remember what state he was in, but somewhere in the South. And he was tried almost 6 times. And just before his sixth trial, I believe, he was fine, or maybe it was the seventh trial, that he was finally released. And I think he got clemency because of the way that I can't remember how it eventually ended, but he is free now. And he was not even guilty. So, and this person was being tried effectively by the state 6 times. So that I just don't think that that should be allowed. How is that right? Anyways, Moving on. So the decision to declare a mistrial is entrusted to the sound discretion of the trial judge. Trial judges receive such discretion to avoid the possibility of coercive measures being used to force jury agreement, thereby protecting the fairness of the proceedings. I don't think judges should have immunity and whatnot. So that's all, and all this, discretion. Allowing judges so much discretion allows for corruption, I believe, allows for bias to set in. In evaluating whether a trial judge abused his or her discretion in declaring a mistrial, a reviewing court considers whether the judge carefully explored alternatives to a mistrial and whether counsel were given full opportunity to be heard, neither of which happened, in my opinion. If these principles were allowed and there is no claim of insufficient evidence to support a conviction, double jeopardy will not prevent the defendant's retrial. And this footnote says the defendant has not argued that the evidence presented at her first trial was legally insufficient to sustain a conviction, and we thus do not address this issue. They should have probably argued that as well because, yeah. Here, we discern no abuse of discretion in the trial judge's decision that the jury were at an impasse and that a mistrial was manifestly necessary. After extensive multi day deliberations, the jury submitted several increasingly emphatic notes about their inability to reach a unanimous verdict. By the time the jury sent their first note, they had deliberated for approximately 19 hours, over 4 days. That note stated that they had conducted an exhaustive review of the evidence and given diligent consideration of all disputed evidence. Following the judge's instruction to continue their deliberations, the jury deliberated for another 5 to 6 hours, spanning a Friday afternoon and the following Monday morning, before sending a second note that was noticeably more definitive. The note stated jurors were deeply divided by fundamental differences and that consensus was unattainable, echoing language from other cases where we have characterized a jury's report of deadlock as unambiguous. Well, that's fine, but there was no clarification still on whether they were deadlocked on one count, two counts, or all counts. There was no differentiation when that was announced in court or in the notes. So it's you can't just conclude, okay, well, because they didn't say that there was a split, then there isn't one. You can't just assume that they weren't talking about that. um, where are we at? All right, so that's all notes. All right, so the second note further emphasized that the deadlock arose not from a lack of understanding or effort, but from deeply held convictions that each of the jurors carried. This is, in and of itself, not what you're supposed to do as a juror. You're not supposed to have deeply held convictions that keep you from making a decision, uh, like what we were experiencing. Like, for instance, maybe someone in that room felt that she needed to be punished because she was drinking and driving, just for instance. And I do believe that there were people in that room that felt that way because otherwise you can't get there. You just don't get guilty. There's no other way. All right, so by this point, the jury has already deliberated approximately 24 hours. See note 5. And defense counsel described them as hopelessly deadlocked. But the trial judge did not immediately conclude that all hope of attaining a verdict was lost. Instead, she issued the Tui Rodriguez charge, a standard instruction that encourages deadlocked juries to reach a verdict by giving more serious consideration to opposing points of view. After nearly 4 hours of additional deliberation, bringing the total of approximately 28 hours of deliberating, the jury submitted a third note that was even more emphatic. It stated that further deliberations would be futile and only serve to force us to compromise our deeply held beliefs. While there is no mechanical formula for determining whether a jury is genuinely deadlocked, the trial judge acted well within her discretion in concluding the jury were at an impasse and the mistrial was manifestly necessary. I disagree. She did not ask, "Are you deadlocked on all three counts?" Okay, yes, no. Then we move on. Then we deal with what the response is. But here, she didn't ask. The defendant contends that despite the jury's deadlock, the trial judge failed to adequately consider alternatives to consider a mistrial. Yet, as discussed, the trial judge did consider and pursue such alternatives. After the first note reporting deadlock, the judge instructed jurors to conclude their deliberations. Um, what was I going to say? Looking at alternatives, like, okay, maybe she looked at one alternative and gave the Tui Rodriguez reading. That's not looking at all alternatives. Then, you're just doing one thing. She had other options available to her, which was, are you deadlocked on all counts? How hard is that? That's all she had to do. After the first note reporting deadlock, the judge instructed the jurors to continue their deliberations. After the second note, the judge issued the Tui Rodriguez charge. It was only when the jury submitted their third report of deadlock, at which point the judge was statutorily precluded from ordering them to continue deliberations without their consent. They couldn't she could not go back, and she could not tell them to go back after the Tui Rodriguez. They could go back on their own if they wanted to, but she couldn't tell them after that. That was like the last time she could tell them to go back with that charge. So the judge declared a mistrial. Nonetheless, the defendant argues that the judge should have inquired whether the jury had reached agreement of any of the charges. Had the judge done so, the defendant asserts she would have discovered that the jury had agreed on counts 1 and 3, allowing for a pretrial verdict. We disagree. A pretrial verdict, meaning she was acquitted. So Rule 27B of the Massachusetts Rules of Criminal Procedure, it gives a trial judge discretion to require a jury to return a verdict for charges on which they have unanimously agreed before declaring a mistrial. Judge may first require the jury to return verdicts on those charges upon which the jury can agree and direct that such verdicts be received and recorded. So a judge may. This isn't must, which is unfortunate that it's not a must that they should um, inquire. Rule 27D also permits a judge to poll the jury when a verdict is returned and before the verdict is recorded. However, a judge is not required to accept a pretrial verdict before declaring a mistrial, and is prohibited from doing so on a single indictment that contains lesser included offenses. Here, the jury were instructed on 3 separate indictments along with 2 lesser included offenses on count 2, but the trial record offers no indication that a partial verdict was imminent or possible, or that the jury even knew that they could do that because it wasn't in the jury instructions. They were very unclear on purpose, in my opinion. The jury's first note simply stated that they were unable to reach a unanimous verdict without reference to any specific charge. The second note reiterated the consensus was unattainable and acknowledged the implications of the jury's deadlock. We learned from Turtle Boy's interviews with the juror, Ronnie, as we now know him. Ronnie did 2 off-camera interviews with Turtle Boy, and then he just recently did an on-camera interview with Turtle Boy, and explained more in depth some of the thought process of the jury, and what was really going on. We know that Ronnie unanimously said we all said counts 1 and 3. We just stopped asking the question. Every day we would ask it, where are we at on that? But eventually they stopped asking the question because they knew that counts 1 and 3, they had acquitted her. So there was no question as to that. Neither note suggested the jury had reached or could reach consensus on any subset of the charges, and we have cautioned against assuming a final verdict exists from general reports of deadlock. As the trial judge observed in her memorandum of decision denying the defendant's motion to dismiss, it, it is particularly striking that the jury notes provided no inkling of agreement on any of the charges. Additionally, the notes did not request clarification on whether pretrial verdict could be returned. This absence is particularly significant given the evident care that went into writing the notes and how articulately they expressed the jurors' disagreement. So this I wanted to bring up as well. Ronnie talked about in his interview that, or in one of his interviews with Turtle Boy, he said that him and one other juror had wanted to send a note to the judge asking about a partial verdict, a partial acquittal, how could they, if they had reached a verdict on some counts and not others, was that okay? What to do in that situation? That's what they were looking for, guidance from the judge, because they didn't have it in the jury instructions. And the foreman and some of the other jurors said, no, we're not going to ask the judge about that. So why not? And and for whatever reason, nobody else took it upon themselves to go and ask the judge, even though the foreman is supposedly like the one who's supposed to talk to the judge or ask the questions. He doesn't have to. Anyone on the jury could if they felt like someone on the jury was being inappropriate and not letting them ask questions. So just so you know for future, if you're ever on a jury and you want to ask a question of the judge and everyone tells you no, you have every right to go and do that. All right, so let's move on. In fact, the jury's third note implied they were deadlocked on all charges. I don't see it that way, but that is how this particular judge or panel of judges saw it. So the note stated in part, some members of the jury firmly believe that the evidence surpasses the burden of proof establishing the elements of the charges beyond a reasonable doubt. Conversely, others find the evidence fails to meet this standard and does not sufficiently establish the necessary elements of the charges. So, plural. So, both times they used plural. So, there was no distinction as to all charges, one of the charges, they didn't specify one charge or multiple charges, and that's what they should have done in their note. Although the defendant relies on post-trial affidavits to suggest the charges referred only to count 2 and its lesser included offenses, we assess the trial judge's decision based on what was known at the time of her decision. As one court has observed, allowing post-trial juror accounts to affect the analysis would create endless confusion and controversy in cases where a mistrial has already been declared due to deadlock. In short, the record before the trial judge suggested complete deadlock. I think you can read it either way, and I don't think you can definitively say that. The first and second notes provided no indication of a partial consensus, and the third note plainly implied the opposite. Again, I don't see it that way. And cases cited the mere theoretically availability of partial verdicts does not obligate trial judge to conduct further inquiry where no party has requested a partial verdict to be taken or the jury does not indicate that it has reached one. Well, it didn't know that it could tell you that because it didn't know how. The jury did not know how to tell you it had a partial verdict. Further still, these notes indicated that additional inquiry into the jury's deliberations risked producing a coerced verdict. Judges must carefully avoid actions that might pressure jurors into compromising their genuine views of the evidence. And we have long recognized that deadlocked juries are particularly susceptible to coercion. Uh, the Commonwealth versus O'Brien. It is precisely for this reason that judges are statutorily prohibited from ordering further deliberations by a deadlocked jury that has twice reported being at an impasse after due and thorough deliberations unless they explicitly consent or seek clarification on the law. They wanted to, and they were stopped. So we know that from the juror interview that they wanted to seek clarification and they were denied. At least 2 of the jurors were told, "No, no, we're not gonna do that." Why? Why wouldn't you want clarification on the law and what to do with a partial verdict? Doesn't make sense that anybody would have said, "No, let's not check on that." Anyways, if after due and thorough deliberation the jury report to the judge twice that they are deadlocked, they shall not be sent out again without their own consent unless they ask from the court some further explanation of the law. The risk of coercion is also heightened when a judge inquires about the possibility of a pretrial verdict following a deadlock. As we have explained, where the jurors have twice reported themselves deadlocked and have already heard the Tui Rodriguez charge, a judge's inquiry concerning pretrial verdicts cannot avoid communicating to the jury the judge's desire to salvage something from the trial. However, the inquiry is articulated or explained, the import of the inquiry is unmistakable. Can't you at least decide a part of this case? The inquiry, by its nature, plays on the deadlocked juror's natural sense of frustration, disappointment, and failure. The jurors are confronted with the request and asked to absorb its inherent complexity at the worst possible time when they are tired, anxious to be discharged, and perhaps angry at fellow jurors whom they blame for failing to reach agreement. In this case, the risks of coercion were evident. After receiving the third note, the judge was statutorily barred from ordering further deliberation without the jury's consent. Far from suggesting that consent might be obtained, the third note made clear that further deliberation would only serve to force the jurors to compromise deeply held beliefs rooted in sincere adherence to their individual principles and moral convictions. Sounds similar to their note. Um, Statutory prohibition on ordering further deliberation was designed to prevent jurors from being coerced into reaching a verdict in the face of views conscientiously reached and held. Asking jurors whether they would nonetheless consent to further deliberation would have implicitly pressured them to compromise those beliefs in order to salvage some part of the trial. In these circumstances, there is simply too great a risk that any resulting verdict would merely be the product of one hasty, final attempt to satisfy the judge's apparent desire for some form of decision on the case. That's not what we're asking for. That's not what Karen's saying, that she should have pushed them to go and deliberate more. That's not at all what she's saying. She's saying they should have she should have asked about a partial verdict. And by failing to do so, she failed to look for other possibilities. And if the judge were to inquire about the possibility of a partial verdict, by definition, any further discussion amongst the jurors regarding their response to the judge's pretrial verdict inquiry would itself be further deliberation in violation of the statute. Okay. Indeed, if the judge had inquired about a pretrial verdict on her own initiative and the jury returned a verdict of guilty on any of the counts, there is no question that this defendant would be making a strenuous and potentially meritorious argument that the guilty verdict was the product of a coercive intrusion into the function of the jury. It's not the function. What? It's not coercive if you're just asking a simple question. Thus, given the entire course of jury deliberations and the emphatic language of the third note that jurors were deadlocked on the charges and that further deliberation would be coercive, the judge acted within her discretion in declaring a mistrial without inquiring sua sponte about a partial verdict, inquiring on her own. The judge was not required to ask jury if they would consent to further deliberations before declaring mistrial because jury had already received Tui Rodriguez instruction and final note unequivocally stated they were deadlocked. For much the same reason, the trial judge's decision not to poll the jury sua sponte to confirm the deadlock before declaring a mistrial did not constitute an abuse of discretion. As we explained in Ray, polling jurors about whether further instructions or deliberation would be likely to resolve the deadlock is discouraged due to the risk of coercion inherent in questioning jurors, particularly in individual colloquies. A trial judge is not required to consider every conceivable alternative before declaring a mistrial, and we discern no abuse of discretion in the judge not pursuing alternatives suggested after the fact by defense counsel based on information obtained after the mistrial was declared. If an alternative which was neither suggested by counsel nor considered by the judge is later developed, we will not fault the judge so long as an honest inquiry into alternatives is made. We have never required a trial court before declaring a mistrial because of a hung jury to consider any particular means of breaking the impasse, let alone to consider giving the jury new options for a verdict. It's not breaking the impasse. It is asking them if you had reached a verdict on any of the counts. Like, that is not, I don't understand how that can be coercive or trying to break an impasse. You're just asking, did you do this already? This is something they already did in the past. Did you acquit her on those charges in the deliberation room? Yes or no? That's not a difficult question. Let alone to consider giving the jury new options for a verdict. The defendant further contends, separately from the availability of alternatives, that it was an abuse of discretion to declare a mistrial without first notifying defense counsel of the consent of the third note, of the content of the third note. Correct, she did not talk to counsel. She got the note, called in the jury, didn't even let the counsel see it or discuss it, and then called a mistrial immediately upon reading it. We know how it goes. We've watched it and we've discussed it in depth. So first, it is worth noting that the trial judge discredited defense counsel's claim that he lacked such an opportunity to be heard. The judge explained that she had previously sought defense counsel's views after receiving each of the first two jury notes. Well, that's the first two jury notes. That's not the third note, Judge Canoni. But when counsel had argued that the jury were at an impasse, so she notified them of the first two notes, but not the third. So that means she gave them enough notification? No, that makes no sense, and they should be ashamed of themselves, the SJC, for putting that in writing. The only alternative proposed by defense counsel during these exchanges was the issuance of a Tui Rodriguez charge, which the judge granted. Hold on. Okay. Uh, sorry. When the third note prompted the mistrial, defense counsel neither objected nor expressed any dissatisfaction, even when the parties remained in the courtroom to schedule a subsequent status conference. In any event, there is no indication that inviting defense counsel to participate in a third round of consultation would have produced any fruitful alternatives. There's no indication, but there's no indication that it wouldn't, and they weren't given the opportunity, so that's a misstep. As discussed, the receipt of the third note barred the judge from requiring further deliberation without the jury's consent because they had already engaged in due and thorough deliberations and twice reported being deadlocked. Furthermore, nothing suggested that defense counsel would have requested an inquiry into the possibility of a partial verdict based on the content of the jury notes. Let's scroll down here. It is difficult to imagine that a competent defense attorney, upon learning that some members of the jury firmly believed the evidence proved the elements of the charges beyond a reasonable doubt, would request that the jury be instructed to return verdicts on any charges where agreement had been reached. As other courts have recognized, a defendant may have a tactical reason for not requesting the trial court to question the jury about a partial verdict, and trial judges should not be required to inquire about partial verdicts on their own initiative. That just seems backwards to me and all sorts of messed up, the way that that is written. Having displayed no enthusiasm for the rendering of a partial verdict while the jury was still impaneled and a guilty verdict still possible, the defense may not seek to overturn the court's order of mistrial after discharge of the jury. While the more prudent course might have been to read the third note to counsel and provide yet another opportunity to be heard before declaring a mistrial, the trial judge did not abuse her discretion in failing to do so. But you just said she should have done that, and then the more prudent thing to do would have been to do that, but she didn't. But we're not faulting her. That's okay. Let her screw up as much as she wants. It's cool. I hate how judges have immunity. It is so disgusting to me. In some, especially judges like Canoni and Gull, they should not be on the bench and should be behind bars, in my opinion. In sum, we conclude that the trial judge acted within her discretion in declaring a mistrial without first inquiring about a partial verdict or offering defense counsel an additional opportunity to be heard. Considering the length of jury deliberations, the judge's prior efforts to encourage consensus, and the increasingly emphatic tone of the jury notes indicating deadlock, it was clear the jury had reached an impasse. Furthermore, nothing suggested that the deadlock was limited to a specific charge. On the contrary, the notes contained no inkling of agreement, and the third note implied the jury were deadlocked on all charges. So says the SJC. Under these circumstances, given the content of the notes and the fact that defense counsel did not further request inquiry, engaging in one sua sponte risks coercing a verdict. Thus, the judge appropriately exercised her discretion in declaring a mistrial based on manifest necessity. Judge did not abuse discretion in declaring mistrial after 4 days of deliberation where jury had reported impasse and received Tui Rodriguez's charge but remained unable to reach verdict and stated in response to judicial inquiry that additional deliberation would not result in verdict. No abuse of discretion in declaring mistrial without first asking whether jury would consent to deliberate further where jury had already been given Tui Rodriguez instruction and final jury note unequivocally stated that the jury were unable to come to a unanimous decision. Because we conclude that the trial judge acted within her discretion in determining that declaring a mistrial was manifestly necessary, we do not need to address the defendant's alternative argument that defense counsel did not consent to the mistrial. Similarly, we do not address the defendant's ancillary argument raised here for the first time that the court should have conducted a colloquy with the defendant before finding such consent. All right, then. Defendant's claims of acquittal. The defendant separately argues that she cannot be retried on count one or count three, regardless of whether the mistrial declaration was proper. She contends that post trial information from five deliberating jurors indicating the jury were deadlocked only on count two and had unanimously found her not guilty on counts one and three effectively amounts to an acquittal of those counts. Alternatively, she asserts that the trial judge abused her discretion in denying a post trial inquiry to verify these counts of juror deliberations. We examine each contention below, and let's read the footnotes here. For purposes of adjudicating the motion to dismiss, the trial judge accepted the purported juror statements as true and accurate. So when Judge Cannoni responded to uh, Karen's motion to dismiss charges one and two, that was what Cannoni said. I take them as fact. I take them as true. These juror statements, because remember, we had at least five jurors coming forward saying they acquitted her on counts one and three, and some of those jurors even were calling the Commonwealth, and Lolly's excuse was, well, I can't talk to the jurors about their deliberative process, so I can't talk to them. So he didn't do any kind of inquiry as to whether it was accurate or true or not or whatever. So, for the purposes of this discussion, we similarly proceed from the assumption that the affidavits are accurate. So, even the SJC is like, yeah, we'll consider the fact that these affidavits from the jurors and the uh, intermediaries and whatnots are all true. We'll just go with that because Judge Cannoni thought that. We'll think it too. So, going forward, we believe the jurors. 15. Juror C did not disclose information indicating whether the jury had unanimously agreed that the defendant was not guilty on count three. I believe Juror C was the one that came up with the whole affidavit, and he got a lawyer and he wanted his privacy and whatnot. So he is the foreman also, so he's a problematic juror. But he did say that she was acquitted on count one, at least, is what they're saying. That they didn't say count three, or he didn't say she was acquitted on count three, but count one, I guess, he agreed. I don't know. I can't remember the specifics, but here we go. All right, so claim of acquittal based on juror disclosures. The Double Jeopardy Clause of the United States Constitution, which is a federal clause, by the way, so it's the same in all 50 states, prohibits retrial from the same offense after an acquittal. To determine whether an acquittal has occurred, we look to whether, given the operation of state law, the jury acted on their view that the prosecution had failed to prove its case. Because this presents a legal question, our review of the trial judge's decision is de novo. What does that mean? Hold on, let's look that up. De novo is a Latin phrase that means anew or from the beginning. Okay, cool. So, because this presents a legal question, our review of the trial judge's decision is a new one. Relevant here, the fundamental requirements for a jury's issuance of a verdict in a criminal case are set forth in Massachusetts R. Crim P. 27A. Pursuant to that rule, a valid jury verdict must be unanimous and returned by the jury to the judge in open court. So just because it wasn't written down and returned, that's the formality. It needs to be the formal process. You need to write it down and return it to the judge. So there's there's no room for error. There's no room for jury error or jury instruction error, none of that. I guess it has to be in open court and whatever. So our case law confirms that a criminal verdict is effective only when affirmed by jurors in open court. The only verdict which can be received and regarded as a complete and valid verdict of the jury which upon which a judgment can be rendered is an open and public verdict given in and assented to the open court as the unanimous act of the jury and affirmed and entered of record in the presence and under the sanction of the court. So even though they said it 100 times in the deliberative or the deliberation room and we're all agreed on it, it doesn't matter because they didn't write it down and present it in open court. So therefore, we should just retry her on those counts again because that's fair. It's so stupid. In other words, the distinction between informal agreement on a verdict and the actual return, receipt, and recording of a verdict in open court is central. Only the latter constitutes a final verdict of the jury on a criminal charge. Well, how about you bring all the juries back into open, or all the jury members back into open court and ask them? That's all you got to do. Poll them, ask them what happened. We have consistently reaffirmed this long-standing distinction throughout our jurisprudence. All right, so this footnote says, see Commonwealth versus Tennyson. So this is this other case that they're referring to. Initial verdict was sealed, but not yet valid because it was not given and affirmed orally by the jurors in open court. Polling of jurors after declaration of mistrial in a murder case showing that 11 had voted to convict defendant of lesser included offense of manslaughter and 1 had voted to acquit was of no effect and did not constitute an acquittal on so much of the indictment as charged murder in the first and second degree. No final verdict where one juror died after jury had unanimously agreed to verdict, but before jury announced that verdict in open court. Wow, that's crazy. How is that not overturned? Juror dies in the middle of proceedings and they don't get to address it in open court, so therefore it's not an acquittal. How is that not overturned? That's ridiculous. But okay. No final verdict where jury had come to unanimous agreement, but where one juror changed his mind, allowing morning or following morning when jury met to return final verdict. That was that long footnote. All right, let's move back up to where that was. In this case, it is undisputed that the jury did not announce a final verdict on any charge. Although the defendant has submitted affidavits claiming the jurors reached an agreement on counts 1 and 3 during deliberations, the only statements made in open court reflected the jury's inability to reach a unanimous verdict. So then, you know what? There's a solution to that, SJC. Make Bev bring them all back into open court and ask them. That would be the ideal solution instead of just saying, nah. As decided, or as discussed, the jury submitted 3 separate notes to the judge indicating deadlock, culminating in a final note indicating that some members of the jury firmly believed that the evidence surpassed the burden of proof, establishing the elements of the charges, while others did not. Far from an affirmation in open court of unanimous agreement on counts 1 and 3, at 57, these notes clearly reflected, whatever this is, see juvenile mass at 57, these notes clearly reflected a lack of consensus on the charges. Even if the jury's deadlock pertained specifically to count 2, their notes made no such distinction, nor did they indicate any verdict would be returned to the judge in open court as required. In the absence of a verdict returned, received, and recorded in open court, we cannot conclude that the jury acted on their view that the prosecution had failed to prove its case. So, it's a formality, this tiny little formality that didn't happen in open court now becomes, well, it's okay. We'll just charge this woman again for crime she was acquitted on. However, fully, it may be made to appear that the jury arrived among themselves at the decision that the defendant was not guilty. There is no claim that they agreed to report or return, or that they agreed to report any agreement, whatever, except that they could not agree. And this footnote says the circumstances of Clark are very similar to those at issue here. There, a defendant argued that he had been acquitted at his first trial after learning that the jury had agreed he was not guilty and had deadlocked only as to his co defendant. Rejecting this argument, the Supreme Court of Tennessee explained agreement on the issue of guilt or innocence is of the very essence of a verdict. We have we have here no verdict reported and none agreed on and intended to be expressed. It is conceded here that the report of disagreement was that intended to be reported. So the disagreement was what was intended to be reported. This determinative distinction runs through all the cases we have examined. That is such horse crap that these people are having to go through trials again, all these people, even though they were very likely acquitted, but the courts just don't want to look at it because it's a formality issue. So ridiculous. The defendant nonetheless argues that any lack of formality in the jurors' intended dispositions of counts 1 and 3 would should not let me restart that sentence. The defendant nonetheless argues that any lack of formality in the jurors' intended dispositions of counts 1 and 3 should not prevent those dispositions from taking legal effect. However, the requirement that a verdict be returned and affirmed in open court is far from a mere formality. Rather, these principles recognize that as a practical matter, jurors may agree in the course of deliberations to a tentative compromise on the facts of a case or on the disposition of related charges as they attempt to reach unanimous agreement. See Bluford. Since a jury should not be precluded from reconsidering a previous vote on any issue, tentative or conditional agreements reached amid deliberations cannot have the force of a final verdict. A jury should not be precluded from reconsidering a previous vote on any issue, and the weight of final adjudication should not be given to any jury action that is not returned in a final verdict. Requiring a jury to publicly affirm their verdict in open court thus serves a vital purpose. There's a remedy. Have Judge Bev bring them back in. It could be, it doesn't have to be on camera, it doesn't have to be publicized, but otherwise you're never going to know. It ensures that the verdict agreed upon in private truly reflects the unanimous and deliberate judgment of each juror under public scrutiny rather than a tentative compromise. Maintaining this distinction between private deliberations and public verdicts is essential to preserving both the confidentiality of jury discussions and the integrity of the judicial system. Thus, because the jury did not publicly affirm that the defendant was not guilty on the charges, there was no acquittal barring retrial under the double jeopardy clause. Signed verdict slips reflecting votes of not guilty found in deliberation room after mistrial had been declared due to deadlock did not constitute as acquittal. So even though it was written, there's this other case, this A juvenile, it's called, where the defendant was, I guess, acquitted on paper, but not in open court. Therefore, it didn't stand, which is, um, I don't know. I kind of see that both ways on that, but uh, you can look at a lot of stuff in the courts in two sides, and that's why it's so crazy that there's all these disagreements. But when you interpret and look at the laws, you can interpret them in different ways. Information indicating that jury were deadlocked 11-1 for conviction of murder, but only in the second degree, and had purportedly agreed that defendant was not guilty of murder in the first degree, did not bar retrial because there was no open and public verdict of a not guilty. A request for a post-trial juror inquiry, which I think is the remedy that should have been given, but this is their rationale as to why not. So finally, we consider the denial of the defendant's request for a post-trial jury inquiry. Generally, a judge is not obligated to investigate jury deliberations unless there is evidence that jurors were exposed to extraneous information or demonstrated racial or ethnic bias. Even in cases of alleged bias, however, judicial inquiry cannot delve into jurors' subjective reasoning or deliberative content. That's not what they're asking. Because the trial judge is afforded broad discretion in assessing whether a post trial juror inquiry is appropriate, we review that determination only for an abuse of discretion. Here, the defendant concedes that the affidavits do not indicate exposure to extraneous matters or juror bias that would suggest her right to an impartial jury was compromised. Contrast Commonwealth versus McCullough. Instead, she argues that the affidavits suggest an unannounced verdict warranting further inquiry. Yet, as discussed, a verdict as a matter of law requires a public announcement in open court. No verdict exists if none was announced. Okay. So it just didn't happen. They just didn't acquit her. Okay. Or even intended to be announced by the jury before they were discharged. So the jury did something wrong because they were misled by the judge and prosecution. They weren't given jury instructions were that equipped them to answer these kinds of questions, and they didn't know that they could ask more questions or were told not to by some of the people on the jury. So there's that. So once the jury has been discharged, they have no further power to deliberate or to agree to a verdict. Allowing inquiry into a private agreement reached in a secrecy of the deliberation room would also contravene our prohibition of probing the content of the juror deliberations. That's BS. That's such BS. That's not, yeah, that's not what they're asking. They're not asking you to probe into the content of their deliberations. No, you're simply asking the result of their deliberations. Maintaining the secrecy of those deliberations is a bedrock of our judicial system. It not only prevents jury tampering, but also upholds the finality of jury verdicts and fosters confidence in the judicial process. Probing secret deliberations to determine whether the jurors may have privately agreed on a verdict they never returned would undermine these fundamental principles. Well, why didn't they return it? Like that's let's inquire about that. What was the problem? Why didn't they return it if they did have that verdict? Let's talk about the issue at hand, that the problem is they weren't equipped, they didn't have the knowledge or the jury instructions to do so, and therefore I believe they were confused on purpose so that this result happened. Just starting to make me mad again thinking about it. All over again. All right, so juror testimony as to part which he or she took in the discussions and votes of the jury is not permissible because it relates to the private deliberations of the jury. Even though post-discharge inquiry asked jurors to disavow the non-existence of a verdict rather than to impeach a verdict already in existence, it still constituted improper inquiry as to jurors' mental processes. Were it otherwise, jurors would be harassed and beset by the defeated party in an effort to secure from them evidence of facts that might be used to set aside a final verdict. And citation omitted there. Nor is the defendant merely seeking juror testimony as to a mistake entered on a final verdict slip, permitting juror testimony about mistakes made in entering the verdict on the verdict form. Here, there is no suggestion that the jury's failure to return a verdict was the result of a clerical error. Post-trial accounts do not dispute that the jurors had reached an impasse as they reported and had decided not to return a verdict slip on any charge as occurred. Contrast in Brown and cases cited permitting testimony to correct clerical mistakes in verdict where jury, without outside influence, immediately indicated error in announced verdict. No juror expressed surprise or disagreement in court when the judge declared a mistrial based on the jury's report. What were they supposed to do? What exactly was the jury's response? Like, the jury's not supposed to just talk out of court. No one's supposed to talk out of hand in court. So what were they supposed to do? They weren't given an opportunity. So whatever. Um, that's not. I don't feel like that's a valid argument because they weren't surprised or in disagreement. Stupid. Anyways, juror inquiry is permissible when jurors audibly answered no during polling of a jury. Yeah, but you have to be polled first, which you weren't done. That wasn't done. So this is not even making sense, this argument. Like, they're all over the place here, the SJC. Additionally, the limited exception for juror testimony concerning mistaken verdicts only results in alteration of a verdict where there had been no opportunity for outside influence. Here, all the defendant's affidavits concern jurors' accounts to others after leaving the control of the court. When jury leave the sterility of the court's control, contamination is presumed. A post-trial inquiry of these jurors would similarly occur well after they become susceptible to outside influences and would not provide a recognized basis for altering the result of the first trial. So you're saying because once they're released, once the jurors are released, then they're somehow contaminated. They're outside that, controlled environment. So now other things that wouldn't have necessarily been permissible at trial, they're starting to learn. But that doesn't necessarily change what happened in that room and what they decided on counts 1 and 3. Some of these arguments aren't adding up to me. Post-trial inquiry of these jurors would similarly occur well after they become susceptible to outside influences and would not provide a recognized basis for altering the result of the first trial. Court could not alter verdict of acquittal upon learning that jury had intended to convict defendant of lesser offense, where jury had ample opportunity to clarify or express disagreement with original verdict when it was announced in open court the prior day. Thus, the trial judge did not err or abuse her discretion in denying the defendant's request for such an inquiry where it would not change the outcome of the defendant's first trial. The jury chose to report a deadlock, not a verdict, and no basis exists for further investigation into private discussions or substantive beliefs they declined to announce publicly in open court. Conclusion: for the reasons stated above, the trial judge correctly denied the defendant's motion to dismiss and request for a post-trial jury inquiry. The case is remanded to the county court for entry of a judgment denying the defendant's petition for relief. So there's that. Immediately after the SJC decision came out, there was a report from Ted Daniel on X. Ted Daniel is with Boston 25 News. He says, I checked with the Norfolk DA's office. A spokesperson told me there will be no statements on the SJC decision. So that was that. Also, afterwards, we've got from Christina Rex. She says, This is from attorney Martin Weinberg. So this is one of Karen's appellate attorneys after reading the denial. While we have great respect for the Commonwealth's highest court, double jeopardy is a federal constitutional right. We are strongly considering whether to seek federal relief from what are violations of guaranteed constitutional rights. So they think that they have a good chance at taking this federally and winning or getting some kind of a result. So that is uh, that is what they are doing. That not this was we were thinking about it. At this point, they have done so already. So the filing's already out. Like I said, it's a 700-page brief. Well, 700 pages total, 35 pages of his brief, and then a bunch of appendices added on of screenshots and things like that. So we won't go through all 700 pages, but we will probably read through the 35-page brief from Martin Weinberg. All right, so now two more things. We've got immediately after this SJC ruling came out, we had responses from jurors. So here's the first one. Info you'll see only on WBZ. This is Christina Rex again. She says, statement from juror in Karen Reed's first trial, whom I have spoken to many times on the condition of anonymity, reacting to the SJC decision to appeal or to deny her appeal, sheds light on the jury process behind closed doors. So let me actually zoom in here now. This is the juror, the first reaction of the first juror to react, I should say. Not exactly surprised. An interesting situation whereby the truth that the jury was unanimously not guilty on 1 and 3, with multiple jurors signing affidavits swearing to that, and the legal process ramifications of these facts concerning to light after the mistrial was declared appear to be in conflict. The SJC ruling means the legal process trumps the truth. At the end of the day, there are lots of pieces to this blame pie from a process perspective, and we, the jury, definitely own a piece. Maybe even the biggest, although we aren't exactly professional jurors and didn't know what we didn't know. They didn't know they could ask questions. They didn't know they could say, hey, can we do a split verdict? They didn't know that. By not making it clear in the jury note that we were only hung on charge 2, that was our mistake. We also didn't know that it would immediately lead to a mistrial at that point without any further interaction with the judge. A simple clarifying question from the judge as part of any trial involving more than one count as to whether the jurors' findings of being hung are related to all counts would easily prevent the situation that had unfolded in this case. I wonder if their appeal to the SJC would have done better if they had included pieces of the conversation that that argument that they had with Judge Bev when it came to the jury form and the issues that they had with that. If they maybe would have put that kind of stuff in there and problems that they had with the jury instructions as to, we didn't have any, the actual. I know we've gone over it in here before, but it's been a while. I can't remember. But there is actual like boilerplate language that you're supposed to use when you have multiple counts with other charges, lesser charges. And she didn't use that. She used basically the same language that you would for one charge for a person pending with, one charge as opposed to 3. So I wonder if they would have had more success in this if they had touched on those issues. But I don't know. Maybe they waived that when they agreed on the jury instructions that they had. I don't know. All right. So this is the final piece I want to bring you. This is the second juror's reaction to the SJC response. So here it says, new in a statement from another juror in the Karen Reed trial in response to the SJC decision today. I have been in touch with this juror since trial and confirmed their identity with my own eyes, but they have not felt comfortable sharing any statements until now. And here is that statement. After serving as a juror in the Karen Reed trial and seeing the chaos that has unfolded since, it is clear to me that the criminal justice system in Massachusetts needs some work. Despite being one of the most progressive states in the nation, so many aspects of our criminal process are antiquated, confusing, and need to be updated. It would not infringe on the role of the jury to require all trial judges to provide clear instructions that help jurors comprehend all aspects of the job they are tasked with. Jurors should know the things that they are allowed to ask for and not. Like, can you get transcripts read back? Can you uh, watch video played back? Those are all the kinds of things that they should know going into that deliberation room. They should know that they have access to resources and evidence, whatever they need. All right. So, and what their role is, like what kinds of things they can and can't do as their role of a juror. Similarly, it would not intrude on the jury's function or the sanctity of the deliberative process to require a uniform process for delivering verdicts and verdict slips, particularly in cases involving multiple count indictments. And here again, that's where I say they should have brought up the fact that the jury instructions that were read were not the typical instructions, and the verdict slip was a mess, and all sorts of things to try to mislead and confuse the jury. Making these kinds of changes to ensure criminal defendants receive a fair trial seems like the bare minimum our courts owe to those whose liberty is on the line. I think that's very well spoken, very well, um, some good ideas that the courts could maybe try to incorporate, but I don't know that they will. But I really wish that they would because jurors, I would say a lot of times, um, people tend to believe the police, they tend to believe the prosecution, and that plays a big bias in your decision making, in your verdict decision making. And those are things that I think need to be addressed. Um, and well, there's a lot of things, especially how how the jury was selected at the very end, the last day, where three or four of like the more pro Karen Reed people on the jury were immediately removed as alternates. The foreman was selected without being part of those alternates. And just the whole process in which the jury was selected was also weird. So there needs to be some something. I think those things needs to be brought to light too, possibly federally. But there's so much with this case. How do we even, which things do you go forward with and what do you let slide? It's ridiculous. So that is where I leave you for this episode. Thank you so much for watching. Let me know what you guys think about the SJC ruling and how lame it was. Um, we're going to, like I said, we'll do the federal or not indictment, but brief. But we will not get to that probably for another couple episodes because I've been sick with the flu, so I have several documents still to get through. So we will, and we're kind of going in order as how they've been submitted, but we've been getting like bombarded with defense and Commonwealth filings. So I'm trying to spread them out and give them to you guys like in segments that make sense. So hopefully, I will see you guys in the next one. Take care and thanks again for watching. Bye now.